Second District Court is now in session. Honorable Megan Stiverson presiding.
Deputies.
I'm sorry, Your Honor, I missed who you wanted.
Mr. Burns.
Mr. Burns. I've seen chairs.
Good afternoon, Mr. Burns. Can you see and hear me okay, sir?
Yes, ma'am.
All right, I have two files I need to arraign you on. One is a new file. That's 220341. This alleges on or about March 23rd of this year, 2022, there's count 1 of police officer assaulting, resisting, or obstructing. It alleges that you did assault, batter, wound, resist, obstruct, oppose, or endanger a deputy Shelby Fellabaum, a police officer of the Hillsdale County Sheriff's Department, that you knew or had reason to know was performing his or her duties. Specifically, it alleges that you refused to follow the lawful commands of police when ordered to exit your vehicle. If you were convicted of this, Mr. Burns, it's a felony that carries up to 2 years in prison and or $2,000 in fines. Count 2 is controlled substance possession of methamphetamine or ecstasy. It alleges that you did knowingly or intentionally possess methamphetamine, specifically that you possessed a plastic bag with a residue of methamphetamine within your front pocket. If you were convicted of this, Mr. Burns, it is a felony that carries up to 10 years in prison and or $15,000 in fines. The second file that I need to arraign you on is file 220191, which alleges a bond violation. It alleges, sir, that you did have contact with Ms. Sarah Stockman on March 17th, 2022 via social media, had resident contact or residential contact with Ms. Stockman on March 17th, 2022, and an exclusion zone contract on March 19th of 2022, contrary to bond conditions. I see that your attorney, Mr. Taylor, is present on your behalf. I first have to ask you, sir, do you understand the charges and the allegations as I have read them to you?
Yes, Your Honor.
And have you had a chance to review your advice of rights, all of the rights that you have available to you in a criminal case, and also on the violation that you have the right to have a hearing on that, sir?
Yes, somewhat. I haven't talked to my attorney fully, but yeah.
Okay, I'll talk to him. I'll talk to him then, Mr. Burns, just to make sure. Mr. Taylor, is there anything, have you had a chance to explain to him? Would you like me to go into more detail about what Mr. Burns's rights are?
I mean, he understands that he has to have a right to have a trial, that he's presumed innocent, the right to testify on his own behalf or to remain silent. He chooses to do so, not have that used against him, and have a hearing on the bond violations also. He understands those rights.
All right. With that being said, then, Mr. Burns, on the new charge, one of the allegations alleged, both of the allegations alleged are felonies. That means you have the right to have a probable cause conference and a preliminary exam scheduled. You have the right to have me address bond on that as well today, sir. So I'm going to get you scheduled for the probable cause conference. Mr. Taylor has entered his appearance on that case, so I'm not going to request an attorney be appointed for you. We're simply going to note that Mr. Taylor is the attorney of record. And then, Mr. Taylor, either on that one, I'm certainly happy to hear argument regarding bond on that new file. And then what would Mr. Burns like to do on the alleged bond violation, sir?
We'd like to enter a plea of not guilty. I would ask that on the R&O and the meth case that it be set for the same dates, April 13 and 20th, which we have the other cases set for. If the court would allow that, but as the bond, can be heard now at this time?
Yeah, absolutely. And then regarding the 13th and the 20th, the court has no issue with that, Mr. Taylor, as long as you and your client are willing to sign the time frame waivers regarding same.
We'd initially signed a time frame waiver for the other cases. I guess it, yeah, I mean, we can do that, get that to the court here.
Or if you just wanted to sign something over, Mr. Taylor, that would be fine too, since he's already signed on the other. If you just wanted to indicate that you are continuing that request.
Okay. As the bond, I'd ask that the court would reinstate his bond that he was on. He disputes all these allegations and pleads his innocence. As to the conditions of his bond under paragraph 4, part U, that states, it's typed in there, no contact with Sarah Stockman. The box is not checked. So I'd ask that the court would consider that, or that condition would not apply as signed under that order. If the court wants to modify the bond to include that box, so be it. Under MCR 6 or 2.602 Paragraph 1, all judgments and orders must be made in writing and signed by the court on the day and dated. Isham v. Isham 311 Mish 240 states that courts speak only through their orders and judgments and decrees. The written orders and judgments and decrees. Tideman v. Tideman backs that up. 400 Mish 571 1997. Kronowski CHRONOWSKI v. Park Sprout Corp. 306 Mish 676 1943. Certainly the other boxes that were not checked here on his bond paperwork do not apply. I would ask that the court would consider that in setting his bond. As to the other allegations in number 2, where it states that an MSP officer was with Mr. Burns when that violation occurred, I'd argue that that was at Mr. Burns's house, and it was over a child issue. I'd ask that the court would consider that for bond. The exclusionary zone, I'd like to address that when the court considers bond, that Mr. Burns was never told where he couldn't go for the exclusionary zones or where they were. I asked the sheriff's department yesterday for where the exclusionary zones are. I wasn't able to get any information. I asked called the clerk's office because I guess the probation officer is the one that sets the exclusionary zones. He's off this week, but the person that was handling that back to me. So we still don't know where these exclusionary zones are. So arguably, it's not really fair to have an exclusionary zone for somebody and then not tell them where it is that they can't go to. I would ask the court to consider that when setting his bond. The social media contacts, we would, he maintains his innocence on those. I would ask the court to consider all those things. He is presumed innocent. And as the court knows, under MCR 6.106, when setting bond, there's a presumption of a personal recognizance bond first, and then and only after that can't be met, then conditions, and then and only then after that is money. Mr. Burns has 2 businesses. He has a concrete company and a gravel pit. He has employees that have missed payday yesterday because he's been in jail. They're relying on him. Other people are relying on him. I would ask that the court would release him upon his own recognizance, and then also because he does have 4 children with Ms. Stockman, that there could be at least a third-party contact for parenting time, because there is no order set up in that.
Thank you, Mr. Taylor. Anything regarding the new charge?
Well, the new charge was directly related to an arrest that came from the warrant that was issued for the alleged bond violations. Mr. Burns does not have a history of substance abuse. He maintains his innocence here on this. He is prescribed some inhalers that, so he does have defenses on this. And there are certain medications, I believe, that can test positive for methamphetamine. He's pleading not guilty on that, and as I said, maintaining his innocence. I would ask that the court would set a PR bond on that case also.
I thank you, Mr. Taylor. And Mr. Burns, the court's had a chance to hear what your counsel has argued regarding bond. I am going to consider the fact that you're currently on bond on file 220191. That's where we have alleged bond violations that have occurred, and I understand the arguments of your counsel, which is why we have a hearing scheduled in this matter. In terms of addressing, I believe it was 2.6021, which indicates that the court's orders must be in writing and signed. The court's still of the opinion that its orders were in writing and signed. Didn't say anything about having to have a box checked or the whole order was void. Specifically, the court recalls, and we can pull up the transcript of that if we'd like, or the video recording, explaining to you in detail what it meant regarding my bond violations. One of the things that the court specifically addressed, which is alleged in the bond violation, is that you delete your email and contacts, so there wouldn't be any accidental contact with the alleged victim in this case. So I have concerns regarding that. Repeated bond violations. We had one before, which was the reason that I had you in here in front of me. You have the right to have your hearing and you're going to have your hearing. Witnesses can be presented. We'll make sure that the prosecutor's office is here and that they have witnesses available to you too. But in terms of that file at this point in time, based off of the information that the court has provided to it, Mr. Burns, I am not going to reinstate your bond. At this point in time, your bond is revoked on that case, and I'm going to put a no bond on it pending the hearing. On file 220341, your bond will be set as the court usually would on an assaulting, resisting, or obstructing. I don't believe that you're of any specific risk to the public because of not following the commands of a police officer, so that is going to be a PR bond. The possession of methamphetamine or ecstasy, the court always takes into consideration potential potential possession charges. I'm going to set you at $10,000, 10% on that. If you were able to post bond on that file, Mr. Burns, you would be subject to mandatory drug screening through the court. You would be required to report to the district court immediately upon your posting of bond so that you could receive a color. As part of your bond condition, you would be required to report for screening at the time of that color. Court is going to place onto the record in exact detail at this point in time, and I'll make sure that it's attached in additional order so that you have a chance to read over it as well. The court's going to continue the no contact. That actually extends while you're in jail as well. You are not to have contact with the victim in this case, or the alleged victim in this case. You cannot call her, write to her, or email her. You cannot send her anything. You cannot go to her address of record. You cannot go where she lives or works if she works outside the home. You cannot have any contact of any kind. You cannot have someone else do any of these things for you except your attorney. You cannot send a text message, instant message, email, tweet, or other form of communication or contact her through any listserv or through Facebook, Twitter, or any social networking site. You should not inquire or comment about her on social media. If you have programmed her into your cell phone, computer, or other electronic device, or have an email address where she is a buddy or friend on any social networking site, you need to delete her name and contact information. Sending a blank or empty message is considered to be contact, since I'm instructing you to make it so it cannot happen. If the communication comes from you, the court will consider it to be contact. It will not be a defense that you accidentally contacted her. If you go to a store, a restaurant, a party, for example, and she is there, you must leave immediately. If you make a phone call from the jail to somebody who you are allowed to be calling and she happens to be there, you need to disconnect the phone call. If she contacts you, you do not reply to her. This is an order of the court. She cannot change, alter, amend, or amend my order in any way. She cannot change it. Only the judge can. If she were to invite you over, ask to meet you somewhere, or contact you for any reason, you cannot violate the court's no contact order. If you do, you will go to jail. If the order needs to be changed in the future, then there will be a hearing regarding that when both sides are present. As it applies to the parenting time, I'm not going to wait until the hearing on this matter because I believe it's appropriate. It's the only time it's been brought up as it was today by Mr. Taylor. What the court will add in the no contact is that upon your hearing and when you are released from jail, Mr. Burns, you would be allowed to have your regularly scheduled parenting time as long as that is through a neutral third party and it is not at the address that she has as her legal residence address or wherever she may be staying. There's usually neutral ground where that can occur. So I'll make sure that that's worded so that you understand how that third party contact for parenting time can occur. We'll see you at your hearing, Mr. Burns. Good luck to you.
Your Honor, can we move up those dates? Then? For the pre-exam conference and the preliminary exam?
I'm not going to reschedule the probable cause or preliminary examinations. He can have his bond violation hearing next week.
What day next week would that be?
I have to get a date for you, Mr. Taylor, to see whether it's, my guess is that it would be on Wednesday, which is always a busy day, but I believe that is when it would have to squeeze in. Can you listen? Not here. What do we have on Wednesday? What's at the end of the day?
All the way to a 4 o'clock exam.
We can schedule, let's double schedule right there on the exams. We usually are caught up.
Okay.
We're gonna schedule it for 4 p.m. next Wednesday, Mr. Taylor. So it's my preliminary examination afternoon, but as you're aware, often those exams either don't go or something happens to resolve them. So I'm positive we'll be able to get in the hearing
Okay,
before the end of the day on Wednesday.
thank you.
All right, thank you. All right, deputies, you can give me Raymond Doolin.
Mr. Doolin. Have a seat, check.
Good afternoon, Mr. Doolin. Can you see and hear me okay? Can you hear me?
I can't hear you that clear now.
All right. Can you hear me if I speak up a little?
Yes.
Mr. Doolin, I need to arraign you on one file, 220-291. This alleges, sir, back on or about January 1st of 2020, one count of criminal sexual conduct in the second degree upon a person under the age of 13. It alleges that being 17 years of age or older, you did engage in sexual contact with a person under 13 years of age. Mr. Doolin, this is a Tier 3 offense under the Sex Offender Registration Act. Pursuant to the law 333.5129, if this court is found, Mr. Doolin, are you having an issue?
I'm starting to hear you saying, I didn't touch the girl. I didn't put my hand in her pants at all.
This is not what this is. I'm doing an arraignment. You need to be seated and you need to listen.
Listen.
All right, so this is the time for the mouth closed and the ears open portion. I want you to listen. You've been charged with criminal sexual conduct in the second degree. It's alleging that you did engage in sexual contact with a person under 13. It's important that you listen to this next part because it tells you what the possible penalties are. It is a Tier 3 offense under the Michigan Sex Offender Registration Act. They have you charged as a habitual offender, which is a second offense notice. They're alleging that you were convicted of criminal sexual conduct in the second degree prior. This was back on February 4th of 1993. This is a felony that carries up to 15 years and lifetime electronic monitoring upon parole from prison. It also requires mandatory AIDS, STD testing, and DNA to be taken upon arrest. Because it is a second offense notice, you are subject to additional penalties, 1 1/2 times the maximum sentence on the primary offense. The maximum penalty cannot be less than the maximum term for a conviction. Mr. Doolin, do you understand? You don't have to agree. Do you understand that you have been charged with criminal sexual conduct in the second degree?
Right, yes.
And have you had a chance to review your advice of rights? The rights you have available to you. So you have the right to plead guilty, not guilty, or stand mute. You have the right to have a trial by jury. You have the right to have the assistance of counsel. So you have the right to an attorney. And you have the right for me to address bond today as well, sir. Do you understand those rights?
Yeah, I understand.
All right. Did you have the chance, Mr. Dunham, did you have the chance to speak with Mr. Doolin?
I did. He wants to plead not guilty. We just asked you to set a reasonable bond.
All right, I'm going to get this scheduled for a probable cause conference and a preliminary examination. Those are hearings you have as of right because you've been charged with a felony. I'm also going to request that an attorney be appointed to you if you cannot afford one. You may be responsible for all, some, or none of the costs of the public defender based upon your ability to pay. So we'll get you scheduled for the probable cause conference and you'll have a chance to speak with your attorney and with the prosecutor, Mr. Doolin. In terms of setting bond, the court is going to take into consideration the nature of the charge, potential risk to the public, as well as potential risk to the victim alleged in this crime. I also have to consider prior history. I do have here in 1993 conviction for criminal sexual conduct in the second degree. There are also assaultive in nature crimes on your criminal history as well, Mr. Doolin. For that reason, the court is going to set your bond at $100,000. 10% would need to be posted in order for you to be released. You, if you were able to post that bond, Mr. Doolin, are not allowed to have any contact with the alleged minor victim in this case. You would also be required to be on electronic monitoring, also known as a tether, where information would be programmed in so that you didn't have any unintended or intentional contact with the victim. You would also be required to follow all of the other terms and conditions of your pretrial release, which includes not leaving the state of Michigan, Mr. Doolin. We will see you, sir, at your probable cause conference.
Step up this way.
Your Honor,
Step up this way.
what
Is
is,
it about bonds, Mr. Doolin?
what did you say about the bond? I didn't hear you.
It's $100,000, 10% would need to be posted. If you're able to post that bond, you're not to have contact with the victim. You would have to be on a tether as well, electronic monitoring, and other bond conditions.
How much was that again?
I'll explain. to you, sir.
$100,000, 10%.
Step
We'll
up
get you the
this way.
paperwork, Mr. Doolin.
You'll have paperwork.
Go. I don't know what you, I can't know what you're saying.
All right.
Deputies, can you give me Brock Adams?
Go see Deputy Jimenez.
Hi, Your Honor.
Good afternoon, Mr. Adams. I have one file I need to arraign you on today, sir. File 220342. Mr. Adams, this alleges on or about March 24th of this year, one count of operating while intoxicated. It alleges that you did operate a vehicle upon Howell Street while under the influence of alcohol or having an alcohol content over 0.08 grams or more per 100 milliliters of blood. It alleges, sir, that your vehicle was stopped after leaving a bar, that you were investigated by police and found through observation and evidence indications of intoxication, and that your blood was drawn. If you were convicted of this, Mr. Adams, it's a felony, or I'm sorry, it's a misdemeanor. It carries up to 93 days and or $100 to $500 in fines, potential for 360 hours of community service. The court could also order rehabilitative programs, cost of prosecution, reimbursement to the government for any emergency response, and expenses for prosecution. Mr. Adams, do you understand that you've been charged with operating while intoxicated?
Yes, Your Honor.
And did you have a chance to review your advice of rights, all of the rights that you have available to you, sir?
Yes, Your Honor.
All right, Mr. Dunham, having had the chance to speak with Mr. Adams, how might he like to proceed this afternoon?
Your Honor, after talking about the possibilities, he indicated to me he wishes to take advantage of the offer of impaired driving that the prosecutor has written up. And so I believe that's what he wants to do today.
All right. Mr. Adams, you understand that if you wanted to, you could have a hearing on this. You could have a pretrial and a trial. My understanding is that you wish to take advantage of this plea offer. Is that what you want this afternoon?
Yes, Your Honor.
All right, so you understand you would be pleading guilty to being an impaired driver. The operating while intoxicated would be dismissed. And I do have on here that at the time of sentencing, they want me to add $76.70 for the blood draw fee. So do you understand that that's the plea offer?
Yes, Your Honor.
Has anybody threatened you or harassed you, told you that you had to come in here and plead guilty?
No, Your Honor.
Has anybody promised you anything other than this plea offer?
No, Your Honor.
Can you raise your right hand? Do you swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You can put your hand down, Mr. Adams. Mr. Dunham, would you mind asking Brock a few questions?
I will, Your Honor. Mr. Adams, is it true that on March 24th, 2022, you were apparently driving a motor vehicle on Howell Street right here in the city of Hillsdale County, Michigan? Is that right?
Yes, sir.
And before the police got involved, you had been consuming some alcoholic liquor, is that right?
Yes, sir.
Enough that you believe your ability to drive was impaired, correct?
Yes, sir.
And you wish to take responsibility for that today, correct?
I do.
Your Honor?
Mr. Adams, I believe that what you admitted to does rise to the level of being an impaired driver, so I will find you guilty of that and dismiss the operating while intoxicated. Mr. Adams, I'm going to schedule you out for a date for sentencing, sir. So once you're released from jail, well, let me fix that for you first. I'm going to give you a PR bond. So you're gonna be able to leave today. Once you're released from jail, I want you to come up here to the district court so that we can get you your notice of hearing and your pre-sentence packet. So there's a page or packet with about 10 pages in there for you to fill out so I can find out some more information about you. In order for me to sentence you appropriately, Mr. Adams, I need a substance abuse assessment. So we can also hand you the list of individuals who are local, who do substance abuse assessments. And we can just make sure that you get with one of those and get me an assessment prior to your sentencing. That's how I decide whether or not you're going to be in jail, on probation, or whether you need probation, all of those things. So you understand that that's important.
Yes, Your Honor.
All right, make sure that while you are out on bond, because I'm giving you a PR bond, this is your opportunity to show that you're not going to have any issues while you're waiting for sentencing. You are not to use, possess, or consume any alcohol, marijuana, or illegal substances. Anything that you don't have a prescription for, you can't take. So make sure that you let us know if you have prescriptions. You may be subject to random alcohol or drug screens while you are on bond as well, which means at any point in time, you could be called and they can have you come in and screen your PBT as well. Do you understand that?
Yes, Your
Is that
Honor.
a yes, Mr. Adams? Okay. We
Yes, Your
will
Honor.
get that, we will get your bond processed then so that you can come on down here to the court and report, and we'll get you your notice for sentencing and everything, okay? Good luck
All
to you,
right,
Mr.
thank you,
Adams.
Your Honor.
Trust and right.
All right, Stacy.
Good afternoon, Mr. Wright. Can you see and hear me okay?
Yes, ma'am. Afternoon.
All right, Mr. Wright, I need to arraign you on one file this afternoon, file 220343. This alleges on or about March 25th of 2022, count 1, operating while intoxicated causing serious injury. It alleges that you did operate a vehicle upon a highway, Meridian Road, while under the influence of alcoholic liquor, and by the operation of that vehicle caused a serious impairment of a body function to a Jacob Luby. Specifically, it alleges that you drove on the wrong way on, that you drove on the wrong way on Meridian Road, and that you were in a car crash. You ended up having a preliminary test of 0.18 grams per alcohol, and caused Jacob Luby, a passenger in the other vehicle, to suffer 2 broken femurs. If you were convicted of count 1, Mr. Wright, it is a felony that carries up to 5 years in prison and or $1,000 to $5,000 in fines, rehabilitative programs, costs of prosecution, reimbursement to the government for emergency response and expenses for prosecuting the defendant. Vehicle forfeiture is possible as well, and if not forfeited, vehicle immobilization is mandatory. Count 2 is the same charge, operating while intoxicated causing serious injury. This alleges that you did operate a vehicle upon a highway, Meridian Road, while under the influence of alcoholic liquor, and by the operation of that vehicle caused a serious impairment of body function to a Margaret King. Specifically, that you drove on the wrong way on Meridian Road, crashed with a PBT of 0.18, and caused Margaret King, the driver of that vehicle, to suffer broken bones in her arm. This is also a felony that carries up to 5 years in prison and or $1,000 to $5,000 in fines. Rehabilitative programs can be ordered, costs of prosecution, reimbursement to the government for emergency response and expenses for prosecuting defendant, vehicle forfeiture, and if not forfeited, vehicle immobilization is mandatory. Mr. Wright, do you understand the 2 charges that you have been accused of?
Yes.
And if you had a chance, sir, to review your advice of rights, all of the rights that you have available to you, so you have the right to plead guilty, not guilty, or stand mute. You have the right to a trial by jury. You have the right to have the assistance of counsel, so to have an attorney appointed to you. And you have the right for the court to address bond today with you as well, sir. Do you understand all of that?
Yes, ma'am.
Because you've been charged with felonies, Mr. Wright, I'm going to schedule you for a probable cause conference and a preliminary examination. Those are 2 hearings you have a right to have. I'm also going to request that an attorney be appointed to you if you cannot afford one. You may be responsible for all, some, or none of the costs of the public defender based upon your ability to pay. But I want you to have legal representation throughout the entire case, sir. Mr. Dunham, did you have a chance to speak with Mr. Wright?
I did. He tells me he works in Elkhart, Indiana for Majestic Security. he certainly would like to get back to work. He would ask to consider that in setting his bond. That's it.
All right. All right, well, the court appreciates that you're employed, Mr. Wright. I have to consider a number of things though, when addressing bond here. I note that you live in Angola, Indiana. That's not too far here from the state of Michigan, from Hillsdale County. So often courts will set an out-of-state bond. I'm not going to do that. I'm going to set you with what I believe to be a reasonable bond, an in-state bond, because I don't think that you're that far away, Mr. Wright. I also have to take into consideration some past criminal history as well, and you do appear to have some issues in the past with substance abuse related offenses out of state. I believe those are in North Carolina. And then there was a public intoxication in Indiana as well. I'm more concerned with the drug-related offenses that you have convictions for in North Carolina. Taking those into consideration as well as what you've been charged with, I have to decide what type of a risk you pose to the public, Mr. Wright. For that reason, the court is going to set count 1 at $25,000, 10%, and count 2 at $25,000, 10%. That brings your total to $50,000. 10% would need to be posted in order for you to be released. If you are able to post that bond, Mr. Wright, you are not to use, possess, or consume any alcohol, marijuana, or certainly any illegal substances. You would also be required to be on a mandatory scram unit, which is a portable device meant to check your breath, your body for alcohol content. You would also be subject to random oral or urine drug screening as well through the court while you're out on that bond if you are able to post that. Mr. Wright, we'll get you scheduled for your probable cause conference, sir. You have a question regarding bond, Mr. Wright?
Yeah, I got a question about the public intoxication. I don't have I never got that charge in Indiana. And I never got a drug charge in North Carolina either.
Mr. Wright, all I have to go off of is the criminal histories that were provided to me on you for both of those states. So you can bring that information up to your attorney. It's one of many things that I address in terms of what I would set your bond at, Mr. Wright. For now, the court's going to make the determination that for the public safety, your bond should be set as I presently set it. Good luck to you, Mr. Wright. We'll see you at your probable cause conference.
Thank you. Yes, ma'am.
Melissa, Ms. Landers. Mr. Dunham, Ms. Landers is present in person. Did you have a chance to speak with her? You can have a seat.
Yeah, I did.
Okay, I just wanted to make sure. All right, Ms. Landers, I need to arraign you on one file today, file 211430. This is a 1-count felony complaint that alleges on or about 5/25 of 2021, so almost a year ago, 1 count of controlled substance possession of methamphetamine or ecstasy. It alleges that you did knowingly or intentionally possess methamphetamine, that you were stopped by police and found to possess methamphetamine in your purse within your motor vehicle. If you were convicted of this, Ms. Landers, it's a felony that carries up to 10 years in prison and or $15,000 in fines. It also requires that unless sentenced to more than 1 year in prison, the court shall impose license sanctions. Ms. Landers, do you understand first what the charge is that you've been accused of? And have you had a chance to review your advice of rights, all of the rights that you have available to you?
Yes.
All right, so you understand you have the right to plead guilty, not guilty, stand mute, you have the right to a jury trial, all that good stuff. All right, Ms. Landers, what the court's going to do, I'm going to schedule this for a probable cause conference and a preliminary examination. So you have a right to both those hearings. I'm also going to appoint an attorney to you. So if you can't afford one, that way you have legal representation throughout the case. There'll be a financial form, which I think you filled out. I see that right here. You may be responsible for all, some, or none of the costs of the public defender. It's based upon your ability to pay. You understand? All right, Mr. Dunham, having had the chance to speak with Ms. Landers, is there anything else that you would like to say on her behalf?
Yes, Your Honor. She tells me she has an appointment with Kim Berger on Monday. I'm assuming that's about hiring her. She says she's been doing very well, job-wise, home-wise, every way, since this date that says this charge came up last year. She heard about this warrant for her and she came and turned herself in. She didn't know anything about it, she says, until then, so she heard about it recently. So she would certainly ask you to let her stay out of jail so she can keep working, go see Miss Berger next Monday, and go from there. Thank you.
Thank you, Mr. Dunham. Melissa, is there anything else that you want to add?
No, ma'am.
All right. you did turn yourself in. That for me means that you aren't at any risk of absconding or taking off on me before the probable cause conference. I have no reason to believe that you're not going to come to that. And this was back in 2021 as well. So I take into consideration the amount of time that has passed as well. I want you to continue to be employed. I'm going to grant you a PR bond. I'm going to put some things on there though, and that's to ensure the public safety, your safety, and to make sure that you comply with the orders of the court. So you can't use, possess, or consume alcohol, marijuana, or any illegal substances, anything you don't have a prescription for. If you have a prescription that you believe that would cause you to test positive for something, just let them know at the front after this. I'm going to put you on colors for drug screens while you're on your bond. So they'll give you a color, you'll have to call in, and they would have you come in and you would screen. And that's so that I can ensure that you're not using while you're out on bond here with the court.
Did they give you the paperwork that, because I'm already kind of doing that at Recovery Services, I've been in there, but I don't mind still doing more.
Okay, I can have you speak if you don't mind waiting out in the lobby here for just a little bit, because I have a couple of hearings after you. I can have Lori come and chat with you so we can see what that is and whether it would qualify. It may. If you're already doing some type of drug screening and it meets the court's requirements, we have allowed that in the past. Okay, so that's going to be the other main requirement. Other than that, Ms. Landers, just make sure that you follow all the other terms and conditions of your bond. Okay, are you interested at all at this point in time if I were to have one of the case managers contact you regarding potential for treatment court if your case progresses? Is that something you might be interested in?
Yes, but I do live in Ohio, so I didn't.
Oh, I didn't know that. So we have an Osseo address for you.
No, that's my mom's address. Me and Chloe live in Montpelier.
Okay, so this was back in 2021 and you have since moved down to Montpelier.
Yes.
Well, I can have case management contact you anyway. Just you living out of state isn't going to mean that you can't have that conversation with them. So I'll put the referral in. Before you leave, make sure that you change the address with the court so that we have the right one. And that may be a good reason for us to do something alternatively with your random drug screens while you're out on bond. The other thing that I'm going to make sure that we put in there is that she's certainly allowed to leave the state since she lives outside of the state of Michigan. Otherwise, that's on there as a bond condition. So we'll get that changed for you as well, Ms. Landers.
Thank you.
Okay, good luck to you. Just have a seat out in the lobby. They'll be with you in a minute.
Thank you.
Are you just at the 516 East Steuben?
Yes. ma'am.
Okay,
thought
perfect. I
did
have
know-
it then.
Okay,
Thank you.
thank you.
All right, they just handed me a file. Do I have an Owen Bowditch here also?
I have somebody waiting to check in.
Mr. Dunham, did you know anything about a Mr. Bowditch?
No, never heard of him.
I've had a couple of people turn themselves in today on old warrants, and that's the new, Bail Reform Act. And so we kind of all find out at the last minute when people are turning themselves in. I don't know if he's one of them.
I don't know.
Well, let's find out.